Lord, I am appearing for respondent number
Appearing
2.
for respondent to filing wakalat.
Respondent number 2. Who's the respondent number 2?
He is the private complainant.
Yes, sir.
And I am appearing for him.
Yes, sir.
Yes, Lord. So the argument is that this can't be extortion. So let's see what is the allegation. Allegation is that these people who control the ED and the ED conducted raids, etc., or started investigations against certain companies.
Yes.
Thereafter, when those companies paid electoral bonds to the ruling party, which was controlling the ED and those governments,
Yes.
thereafter, the harassment by the ED stopped. And in this way, they were extorted of money through these electoral bonds. Now, my learned friend said that this can't be extortion. Just see the definition. Your Lordship is aware of the definition of extortion.
Yes, sir.
Whoever intentionally puts any person in fear of any injury to that person or to any other and thereby dishonestly induces the person so put in fear to deliver to any person any property or valuable security or anything signed or sealed which may be converted into valuable security commits extortion. Now, if they put the fear in the minds of the companies that the ED will arrest them or the ED will raid them, etc., and thereafter, my lord, they are forced to buy electoral bonds to give them to the party which controls the enforcement directorate. And thereafter, the enforcement directorate stops the action against those companies. This is a classic case of extortion. What else is extortion? Therefore, how can anybody say that this is not extortion? And what has been done? Only an FIR has been directed to be registered. In fact, even the Supreme Court, when it gave the judgment in the electoral bonds case, had said elaborately that they fear that these bonds may be used for bribery, for quid pro quo, etc. And this is what appears to have happened. It is not merely quid pro quo, it is actually extortion by putting the fear of arrest, putting the fear of raids, etc. in the minds of those people running those companies and thereby inducing them to buy electoral bonds. And after electoral bonds are bought and given to the ruling party, thereafter everything is stopped. This is absolutely the classic case of extortion. And only an FIR has been ordered to be registered. Investigation will follow now. When we went to the Supreme Court asking for a court-monitored SIT into these offences, court said, yes, offences may have been committed. But for that, there is no need for an SIT. Let the law follow its normal course. That means let the normal criminal procedure be applied. And that's what exactly has been done by the complainant. He made this complaint to the magistrate that this investigation needs to be done. He first filed the complaint. Thereafter, when nothing was done, he went to the magistrate. The magistrate has only ordered an FIR and an investigation. And these are the people who are, among others, who will need to be investigated in this extortion. So therefore, my lord, it's a perfectly valid case. And at this stage, my lord, at this stage, no plea can be raised that sanction has to be taken at this stage, because sanction will be taken at the stage of taking cognizance.
That is not the plea also.
Yes, that's not the plea.
That is not the plea presently.
Yes, yes. Today the plea is only that this is not a case of extortion. And I am saying that this is the most classic case of extortion. If ever there is a case of extortion, this is it. When you put the fear of arrest and put the fear of raids, etc. in the minds of a company and thereby induce them with that fear to give electoral bonds to the party which controls the ED, and thereafter the ED stops the action. What else is extortion? This is classic extortion. And I submit, my lord, that there is, if your lordship wants to issue notice and hear this case, that is all right. We don't mind that. But there is no case whatsoever of any interim order to stop any investigation at this stage. No coercive action is being taken against these people. Right now, only an order for investigation has been made that an investigation should take place. Why should the investigation not go on in such a classic case of extortion? This is my respectful submission, Lord.
Yes, state.
You are ready to commence investigation. It was referred to. You are ready to commence investigation.
Yet to commence.
Yes, yesterday it was referred. So therefore, you will not be able to say anything prior to the investigation. You will also.
Yes, will answer. The petitioner is before this court calling in question registration of a crime in crime number 224 of 2024 after it having registration so and so, for it having been registered on a reference being made by the learned magistrate in PCR 4880 of 2024 under section 156(3) of the CRPC. The second respondent claims to be the co-president of Janadhikara Sangarsha Parishat JSP and is the de facto complainant in the case at hand. It is the case of the complainant that the case of the complainant before the concerned court that the accused in the case at hand, accused number 4, along with other accused, have indulged in extortion. Extortion to mean an offense under section 384 of the IPC and the allegation stretches to section 120B read with 34 of the IPC.
383, my lord. Extortion is
No,
384.
I'll answer.
I'm sorry.
That is
I'm sorry.
384 is punishment for extortion. Yes. So and so. The learned senior counsel KG Raghavan, taking this court through the documents appended to the petition, would prima facie demonstrate that there is no case of extortion made out in the complaint or in the reference made by the learned magistrate seeking to investigate into the matter. The learned senior counsel would submit that the complaint itself is so vague that the complaint itself is vague and does not make out any ingredient of extortion, qua the complainant. Per contra, the learned senior counsel, Prashant Bhushan, right?
Yes.
Prashant Bhushan, representing the second respondent complainant, would vehemently refute the submission to contend that this is a classic case of extortion where the accused number 2, who's accused number 2?
ED.
Accused number 2, the enforcement directorate, have put fear in certain companies to execute electoral or to take electoral bonds as a quid pro quo, and the apex court, while dealing with the issue, has left it open to the aggrieved to take recourse to remedies available under the law governing both criminal procedures, i.e. ordinary law governing criminal procedure. It is the submission that taking cue from the order passed by the apex court, the complaint is registered before the learned magistrate and therefore the crime should be permitted to be investigated into. I have given my anxious consideration to the submissions made by the respective learned counsel. At this juncture, the issue is whether the investigation should be interdicted or interjected on the score that the offenses would meet or the ingredients would meet the offenses or otherwise. What is alleged is section 384 of the IPC. Section 384 reads as follows. It deals with punishment for extortion. The ingredients of extortion are found in section 383. Section 383 reads as follows. Section 383 mandates that any informant who approaches the concerned court or the jurisdictional police should have been put into fear And due to that fear, he should have delivered some property to the accused. It is only then extortion can be established prima facie against that accused, qua the victim. It is settled, next para, it is settled principle of law that criminal law can be set into motion by any person. But there are provisions under the IPC that they should, or they can be set into motion only by the aggrieved. To illustrate, offenses of assault, offenses of thieving under section 379 or extortion under section 383. It is only if the accused has put the victim under fear, a victim would mean the first informant, under fear to deliver a property, it is then it would amount to extortion. If the ingredients of the case at hand is noticed, who is the complainant becomes significant. The complainant is the co-president of a Janadhikara Sangarsha Parishad. It is not his case that he has been put into fear to deliver any property to the hands of to his hands. It is not his case that he has been threatened of any parting with any property. Therefore, the complainant in the case at hand, if he wants to project section 384 of the IPC, should be an aggrieved informant under section 383, which he is not.
Lord, I just wanted to point out, I don't want to interrupt your lordship.
Yes, sir.
That this A.R. Antule's judgment, which is a constitution bench judgment.
Yes, sir. Anybody can set the criminal law into motion.
Yes, para 6
Yes.
says, and it says that unless there is a specific bar
Yes, sir.
in the criminal procedure code, only
Yes,
in
sir.
those cases,
Hmm.
complainant has to be an aggrieved person.
No,
Otherwise,
if somebody else has been extorted for delivering property, how can somebody else register the crime?
reason is simple, my lord, because two reasons. Firstly, in any crime, my lord, generally all society, it's a crime against society, and therefore anybody in society is interested.
384 is not a crime against society, sir. It's crime against an individual.
Lord, any crime, whether it is murder also, murder is also a crime against a particular person.
That
But
is
it's
true.
a crime against society. And therefore you don't want such criminals to be roaming free, and that is
It's all
why.
right, sir. I'll pass the order. I'll consider that submission also, sir.
Second reason is, my lord,
Yes.
that in a case of extortion of this kind,
Yes.
obviously the complainant will not come, the person against who has been extorted will
No.
not come forward because he has got the relief of being.
No, that's a different thing. That doesn't mean somebody else can shoot from somebody else's shoulder.
No, my lord, this is precisely the reason why the Supreme Court said that unless there is a specific bar under any provision of the CRPC, that only the complainant can make the complaint, anybody can make the complaint. And I submit, my lord, in extortion, there is no such specific bar. No such specific bar. And this is also for the reason that in this case, my lord, the victim will not come forward because the victim is also the beneficiary. He has been extorted, but he has also benefited from inaction on the part of the ED. Therefore, he is not going to come forward.
All right, sir. I'll answer it. I'll note your submissions also, sir.
Complete answer to my learned friend's submission, my lord, is section 39 of the CRPC.
1 minute. Yes. The Ali, sir, the submission, we went to sir's submission. Sir, Prashant Bhushan, sir, you quote there. Other Munche Raghavan sir heli. The learned senior counsel KG Raghavan would further contend that section 384 cannot be invoked by any person. It is an exception to the concept of any person can set the criminal law into motion. Ali, Prashant Bhushan sir atra. The learned senior counsel Prashant Bhushan would further contend that the criminal law can be set into motion by any person is the law laid down by the apex court in the case of A.R. Abdul Rahman Antule versus R.S. Naik. So and so in 1984. In 1984.
Unless there is a specific bar.
Yes,
1986 to SCC 716.
1986 2 SCC reported in 1986 2 SCC
No,
716.
but it's actually no. It is
It's
the
84, sir. That is different.
Citation
Locus ಹೇಳಿರೋದು 84 ಅಲ್ಲಿ.
1984 to SCC,
Yes,
page
that is a
500,
different
para
judgment.
6. Para
Yeah,
6.
that is 1980. Locus is said only in 1984.
84
Yes,
to
1984,
SCC,
so and
page
so.
500,
Yes, so.
para
On
6 actually.
Last again.
On extortion, this is the judgment.
ಯಾವುದು?
On extortion, Antule's judgment is this, which I am referring to your lordships.
No, locus ವಿಷಯವಾಗಿ.
Oh,
Anybody
locus.
can set the criminal
Well,
point to motion.
Yes. I follow. I follow.
The learned senior counsel for the petitioner would join issue to contend that the judgment of the apex court in the case of A.R. Antule, 1986 so and so, answers the issue of locus qua the offense under extortion.
83.
Now come to the end. Last line held. Should be a person who is put into fear to deliver any property or valuable security to the accused. The issue need not, the issue in the case at hand is not that the complainant has suffered any fear at the hands of the petitioner, accused number 4, or the accused as the case would be. It is the case that they are a, what organization you are, sir?
It's called the Janadikar
Janadikara Sangha Parishad.
Sangha Parishad.
Purpose.
That's a registered trust.
So and so, the respondents are, and they are entitled to register the crime for extortion in the light of the finding of the apex court in so and so. So and so.
Also because not the complainant, the victim will not come forward in this kind of a case.
That's all right. Yes, so and so. The learned magistrate, while referring the matter to investigation, has observed as follows, page 33 to 35. Nowhere the learned magistrate observes that it is the victim who has suffered at the hands of the petitioner, the accused, for parting away with property on a fear that is injected into him, unless that is the ingredient of, unless the complaint meets the ingredient of section 383 as observed herein above, permitting investigation even prima facie till the statement of objections are filed by the respondents would become an abuse of the process of the law. In that light, I deem it appropriate to interdict further investigation into the matter till the objections are filed by the, till the next date of hearing. List the matter on, when do you want it, sir?
As soon as possible, my lord, we will
We
file
are,
our
we
reply
have a
within
vacation up to
3 days.
14th. I'll list it on 14th or 15th, whenever you want.
Can it be a few days after that, my lord? I will not be here. Can it be after 21st?
All right, no problem. List on 22nd in the fresh matters list.
Yes. Great.
Yes.
Great.
Special court. So and so. I'll add 1 or 2 judgments if you permit in the order, including this. Prashant Bhushan sir is there.
I would respectfully,
And
my lord,
your lordships may look at 39
I would-
also the
I would-
No,
CRPC.
it's all right. 1 or
request
2
your
judgments, if I
lordship-
am permitted to add, I will
No,
add.
Yes,
in the
my
order.
lord, your lordships are.
No,
My
that's,
lord,
no, it
please-
should not be said. It was not dictated. It is added there.
my lord,
From my side, my lord.
please include this submission of mine that in this kind of case where
That I will
the-
include, sir. I will include that and answer it also.
yes, I am
Because a lot of advocates are waiting, so I'll do that.
very well. I am
Yes, sir. Yes.